Okay, I want to welcome everybody. My name is Brian Horlick, and as you know, we have a AMA Ask Me Anything every Wednesday at 12 o'clock noon, and we try to answer all questions from managers, condo managers, residents, owners, board members, industry professionals, industry hanger-ons, and everybody else who'd like to ask a question and get a somewhat coherent answer. So the latest and the greatest news, as many of you may be aware, is the government extended the emergency order for another 10 days till June the 9th. I think it's June the 9th. And what that means basically is that the emergency order stays in place for another 10 days. It was supposed to finish May the 29th. That, of course, means that unless there are any changes, the bars and restaurants will continue to be closed. All of the orders that were in place and that were due to expire on May the 29th will continue. Disappointing for some, but really expected in light of the ongoing COVID-19 situation. I think it would be unreasonable for anyone to feel that at this point in time the emergency orders should have been moved. So things will be continuing as they are. For those of you who are new to the YouTube live stream, my name is Brian Horlick. I'm a condominium lawyer for over 30 years, toiling away in the trenches. I will tell you that we started the YouTube channel at the beginning of the emergency order for COVID-19. We did that because we felt that in our business, condominium lawyers, it's a very active business. We're constantly in contact with property managers, condominium managers, auditors, board members, and there seemed to be this void in that everybody was hunkered down in their homes, not working, or in their offices, which were closed up if they could be in their offices. Everybody was practicing social distance, and we thought this was a way in which we could keep the community together. People would have similar questions and similar concerns, and we thought this would be a good idea to do this on a weekly basis. So, as you know, we do this every Wednesday at 12 o'clock noon. We go as long as there's questions, usually no longer than an hour, sometimes 45 minutes. So the AMA Ask Me Anything, we have that every Wednesday at 12 o'clock noon. In addition, many of you know that we have a COVID-19 FAQ, frequently asked questions, that our office sends out every Monday. So the area dealing with emergency orders is changing all the time. It changes rapidly. It can change numerous times in a week. For those of you that are board members, for those of you that manage condominiums, you need to have at your fingertips what is the latest emergency order dealing with COVID-19. That's the only way you can properly manage your buildings. And so every Monday you can expect an up-to-date FAQ from our office. If you have the FAQ, you will notice that there are footnotes throughout the FAQ. If you click with your computer onto the footnote, it takes you to the exact source material, which usually is a information sheet from the government that sets out their order. So we summarize the whole thing for you, and we put out the footnotes. It's a very comprehensive document, always being updated. If that wasn't enough, you've got the AMA, you've got the COVID-19 FAQ. We're doing now something called Case Law Corner. Each one of our lawyers is taking an opportunity to record a 2-minute video on a condominium case, a legal case that was decided in the courts dealing with condominium law. We do a 2-minute video recording, and we send that out along with a brief summary of the case. So if you're a board member, a unit owner, a resident, a condo manager, these are must things for you to read. I will tell you that the first case that went out was done by Ann Nguyen, one of our associate lawyers. That case dealt with an application by a unit owner with respect to noise coming from her neighbor, which noise was not properly dealt with by the condominium corporation. So that's a very excellent case. If you have noise issues in your condo, it sets out really what are the obligations of the condominium corporation in face of noise issues. In addition, we have another case that went out dealing with water penetration. And basically, you cannot live in a condo corporation without having a flood, especially a high-rise. And so dealing with or reviewing a case that dealt with water penetration and how that was dealt with is very important. That case was done by Paneet Bandal, also one of our associate lawyers. The next case we did was based on an unsuccessful oppression application for a special assessment. So a board levied a special assessment. They needed money for the reserve fund, and one of the owners thought that that was oppressive, that they would actually have to pay a special assessment to top up the reserve fund. So that case was reviewed by Alex Etkin, who is our articling student. Alex is fully fluent in Mandarin, and if you watch that video, in the first minute or so of the video, he shows off his wonderful Mandarin skills, and then he flips over to his equally wonderful skills in English. Our fourth video was done by Bharat Kapoor, and that was also dealing with oppression, where an owner felt that he was wronged. So all of these videos are available. If you haven't received them, you can email us. There's a subscribe button here as well, and you can subscribe to our YouTube channel so you'll be kept up to date with all the things that are going on. Now, the case law videos come out every Friday. I will tell you this Friday we're doing something special. No, we haven't found the cure yet for COVID-19. It's not that special. But what we're doing is something called Condo Spotlight, and that is an interview session that Bradley Chaplick of our office is doing with somebody who is a mediator, and the mediator's name is John Jacobs. And Mr. Jacobs has opened up a mediation office, and it's called the Canadian Cannabis Dispute Resolution Center. So if you have a cannabis issue, a smoking odor / cannabis issue in your condominium that cannot be properly resolved, and it's a nuisance to owners, and if you have in fact a no smoking rule or not, then you would absolutely need to have the matter resolved. And one of the ways, of course, is mediation between the parties. So if you tune in, or rather if you'll take a look at the video, because we'll be sending it out on Friday, you'll see Bradley Chaplick and John Jacobs discussing mediation regarding cannabis for the Cannabis Dispute Resolution Center. That's quite the name. Now, moving on, I want to give Doug Ford a shout out for doing the great job that he has been doing and continues to do. Now, Doug, if you're listening to us, I know you're listening to us, you need to take care of what's called the COVID idiots, the COVIDiots. And the COVIDiots came out in full force at the Trinity Bellwoods Park last weekend. There was 10,000 people crammed into this park drinking beer and having a grand old time, because when you're young and single and beautiful, and that's not me, you can never get sick. Well, that's what people may think, but they can get sick too. So COVIDiots, please listen to the Premier and listen to the Mayor, and don't do silly things, foolish things that put the entire province, all of the healthcare workers, and all of the residents of the province at risk. So again, June the 9th is the extension of the emergency order. So everything that's been going on is going to stay the same. I will tell you that to recap on the regulation, which came out just after the Victoria Day holiday, there was a loosening up of some of the restrictions, and that's because we are in phase 1 of the reopening of Ontario, which means that the province is loosening some restrictions, taking a wait and see, gradual, conservative approach to make sure that the COVID cases do not increase. So, in a nutshell, there's been a number of loosenings. Parks are open. You can walk through parks. You can, sit in parks. You can sit on park benches, but you must keep in mind social distancing of 6 meters. You still cannot have social gatherings of more than 5 people. Outdoor pools closed by the emergency order. Whirlpools, spas closed by the emergency order. Outdoor fitness equipment closed by the emergency order. You can have gardens, allotment gardens, and you can have tennis courts. You can use tennis courts, but again, social distancing. Putting greens are okay. Again, social distancing, as well as golf courses. So let's go to some questions here. So we have Julia Lurier. Hello. So hello, Julia. Julia is one of our associates who has now taken up at the moment the task of raising one little baby and one little toddler. I guess, are you a toddler at 3 or 4? So she's super busy with that. She'll be coming back to work in November, and we can't wait. All right, question. Ulana. Hello. How do I sign up for your FAQ info? Well, Ulana, if you can send us you can send us an email, bhorlick@hldlawyers.com, and we will put you on the list, and you will get the FAQ every single Monday until COVID is done. Next, Olivia. Hi, Brian. How are you? I believe you answered this question before from your past episodes. Are we allowed to hold the 2 AGMs until 2021, where we would hold an AGM covering the 2 fiscal years? So I think what the question is if you don't have your AGM in 2020, right? You haven't had your AGM in 2020, you will have to have it pursuant to the amendment to the Condominium Act. You'll have to have it within 90 days of the end of the emergency order. So you will have to have that. But let's say the emergency order doesn't end in 2020, and let's say the emergency order ends in 2021. Well, unless there are further amendments to the Condominium Act, you would have to have your AGM, let's say in 2021, the emergency order is over, and you will therefore move forward within 90 days. And what you will do at that point, because it's 2021 and you haven't had your AGM in 2020, what I would do is I would put on the agenda the audited financial statements for 2020 and the audited financial statements for 2019, right? So you're going to have, and I would have the auditor discuss both financial statements. I would pass the minutes from 2019. I would pass the minutes from the year before, so you'd have the minutes to be passed, but I would definitely have, it would be one meeting, and the only real thing that you'd have to do there is in addition to the approving of your last minutes and your review of the audited financial statements for 2 years, you'd have to have your elections, and that might be something that's a little tricky based on the end of the terms. But you'd have one meeting, you'd have all your business done at that same time. Harlan Stavis. We have requested that residents and visitors wear a mask when in the common areas. There is a supply of masks for visitors and residents to wear in the common areas. What can we do if a mask isn't worn? So first of all, Harlan, let me tell you that I think the provision of masks, the encouragement to wear masks is an excellent idea. You know from reading the newspaper. I don't know you read a newspaper because you're an old guy, but reading the news on the internet, listening to the news on other sources, the health authorities are saying that you should wear a mask in areas where social distancing is not always possible. I was actually, I went to Costco yesterday for the first time since the COVID-19 matter hit. And when you go to Costco, there's a big sign that says, we encourage you to wear a mask. And they have masks there for you. So it's a great idea. I fully support that as a condominium lawyer. There are areas in the common areas where it is impossible, for example, in a hallway, to pass people and have the required distance between the people. And therefore, if you don't have the required distance, you should be wearing a mask pursuant to the order, the emergency order of the province. So the question really is, can you force residents or can you force visitors to wear that? My feeling is this: if you passed a rule, you could enforce a rule. So rules deal with health and safety and security. And this clearly to me is a safety and security issue. I would suggest that condominium corporations seriously consider passing a rule with respect to masks. The rules, of course, have to be reasonable. And so for young children or people that may not be able to properly breathe in general, and the mask, of course, would be a hindrance, there would have to be some limited exceptions, but I think it would be an appropriate thing for a rule. Next question, Urmelindo. Well, that's just ha ha ha. All right, next. Somebody put up here the link to the FAQ. So there's a link there, and you have the ability to go on that link and press. There's a certain box you can press that will automatically hook you up to our FAQ. Next here is Julia Laurier. She can't wait to be back. All right, Julia. For those of you that don't know Julia, you should. And for those of you who know her, you'll never forget her. And I'll leave that alone now. Next, Danielle Brooks. Hello, Brian. Is it now time to request access to units for building maintenance items such as heat pumps? Well, the question is now a good time? So the government has now opened up the list of people that can carry on business in Ontario. Construction was limited to essential services and emergency type of repairs. That provision in the emergency order has now been removed, so maintenance and repairs and construction are fully open, meaning that you can do your landscaping, you can do your outside renovations, you can even do your lobby renovations, you can do inside renovations to units. The question really is, the law allows you to do this, but should you be doing it? I think condominium managers and unit owners / residents alike must use some common sense. And you need to ask yourself, although you could do it, the question really is whether you should do it. And I would say this, I look at the COVID numbers and they start to go down. And there's a part of me that says that's great, but soon they'll go up. And they actually went up again for the last, few days in Ontario, only to start going down again. So I would think that unless something is urgent, if I was a owner or resident, I would be unhappy to have people coming into my unit in general. I just wouldn't be comfortable with that. I know here in our office, and I've been working in the office throughout the COVID-19 experience, but there's only been 3 people working in the office, so we have lots of room for social distancing, so that's not an issue. But we have some work that we would like to get done too, and we have really held off on that and continue to hold off on it because we're just not comfortable to have people in. So it's really an issue of comfort at the moment. Next question, Alexandra. Hi, Brian. What is your opinion on the temporary hidden cameras in the common elements in hopes to catch persistent smokers in the stairwells? I like it. That's my own personal opinion. But the thing with hidden cameras, you need to disclose that the premises are under surveillance. You need to disclose that, and corporations are strongly urged and encouraged that they need to have signage, and the signage has to be properly, as you're walking into the building, there should be some type of a sign that the premises, are subject to video surveillance. And that is part and parcel of one of the things that you need to do in order to have, surveillance on the premises. Now, of course, if you have cameras that aren't hidden, and they're out in the open, or if you have a sign, in this case a sign in the stairwell that says, hey, smokers, if you're going to smoke, smile here, that's not going to be helpful in catching them. So I'm of the view that general signage is appropriate, and general signage is appropriate as you walk into the building. You can make a sign that says the premises are subject to video surveillance, or the common areas, and leave it at that. And if you heard one of the previous sessions, we had a situation where somebody was causing damage in the saunas, in the sauna room at a condo corporation, and the question there became, should we put a video surveillance camera in the sauna, and the camera would only show the male body from like the chest up. Thank God. Because he was no Arnold Schwarzenegger, this guy, I'll tell you that. But in any event, a video surveillance camera was put in, and we were able to nab this fellow as he continued to cause damage to the electrical equipment in the video surveillance camera. Not in the video, in the lighting of the sauna area. So signage is very important. Alana, we are preparing to open our outdoor barbecues. Can we put the onus on residents to wear masks and bring their own disinfectants for high-touch areas? Or do we supply masks and have our staff disinfect? Well, these are all good questions. So really and truly, you have to keep in mind that A, you can't have social gatherings of greater than 5 people. B, you must have social distancing of appropriate distance between people, because that's the part of the order from the Ontario government. It's problematic if you have, people, using the barbecue. But what you would have to do, you'd have to set up specific times and specific rules, and like you have to book appointments to use this thing. The question really becomes, should you have people using masks? I mean, it's not a bad idea. I'm not a doctor, but COVID is supposed to spread through communities and through people speaking and saliva droplets. I'm gonna not be. I mean, I think it's a doable thing. I don't know how comfortable I would be. I have heard that some condos are now opening up the barbecue areas. That in itself, leads to, how do you get to the barbecue? How do you take your food down? Then you have to take your food up. Then you have, less than the appropriate amount of room in the hallways. It's fraught to me with issues, and although it's possible, I'm not a great fan of it. You're going to put in a rule in place that you have to wear masks, and then some people are not going to wear masks, or they're going to wear them and take them off, and people are going to be touching the same areas. So can you do it? You could do it. Is it a good idea? I would say no. I would not be thrilled with that idea. I think we have to continue the conservative measures that we've been taking, because really and truly we have to get rid of this disease, this virus, and we need to work hard to get rid of it. And if that means we can't have a barbecue outside, or we can't be a COVIDiot, let's not be COVIDiots. Next, are renovations in units now allowed, i.e. remove and replace floor, paint, and in the unit? This is from Leo Alvarez. The answer is yes, renovations in units are now allowed. As you will recall, there was an emergency order that came out that said, I think it was April the 3rd, if I'm correct, that any renovations that were done up to that point could continue, but if they were they couldn't start afterwards. But on the most recent order, which came into effect, I guess that must have been that was probably the Victoria Day most recent order. The order was lifted, it was rescinded, and so you can now do renovations in units as you can do throughout the entire building. But again, it's not open season. Things aren't the way they were. You're going to have to put in place, certain type of restrictions. How many units can be renovated at the same time? How many different trades will be allowed to go up and down the elevator, differently, separately, or together? How's that all going to work? And you have to really think that through, because if you have a large size building, you could have 8 or 10 renovations going on at the same time. And, obviously your community where people are still, not able to work, many people, and they're still staying home, you don't want that to turn into a noisy construction zone. So everything has to be done, using a common sense approach. WC. Hi, Brian. With a majority board vote, it's already a bad question. Can board titles be reappointed from time to time during the course of a year? That would include the president's title. What instances can allow this to happen? So the bottom line is this. The president has to be elected by the board members. That's an elected position. Everybody else basically can be appointed. There's no term for the officers. And so at any point in time, if the board was unhappy or wanted to make a change, then the board could say, somebody could put it on the agenda to have a vote for the president, or put on the agenda, appointment of officers, and you could have these things done. It doesn't have to be at the end of the person's term or at the end of the year. So again, for president, it's a vote by the board, and it's the majority of the board. For the other offices, it's an appointment. Just make a motion, somebody seconds it, and you vote all in favor, and away you go. Or you can just say I appoint, and if the majority group appoints is in agreement, then that will be satisfactory. Jerry DiDonato. Good afternoon, Brian. Our year end was Jan 31st, 2020. Under the current restrictions, what is the latest date that we can hold the AGM? Well, Jerry, the amendments to the Condominium Act, which now say that your AGM has to be held within 90 days of the end of the emergency order. There's another provision that says if the emergency order ends and your AGM was scheduled to be held within 30 days of the date that it ended, you have 120 days within which to hold the AGM. So right now, we still have the emergency order. It was extended to June the 9th. I'm going to tell you this. We are still in phase 1 of reopening Ontario. I don't see phase 2 happening for a while, especially if people are going to take advantage of the loosening up of the rules, loosening up of the order. If the I was going to say condo cases, tell you where my head's at. But if the COVID cases continue to rise or don't have a significant decrease on over 2 to 3 week period of time, we're not going to see a further reopening. We, in fact, may even see a further tightening of the rules because health and safety is first. Okay, condo is second, but health and safety is first. Next question here, Phil Usprech. If an owner and his lawyer has advised us that his client will not wear a mask and doesn't have to observe the social distancing rule of 6 feet, and can a bylaw be called? So we have discussed this. I'm suggesting that it's not a bylaw issue, it's a rule issue. And if the corporation feels strongly that masks should be worn in the common elements, I would suggest a rule could be passed, should be passed, because again, that's a matter of health and safety. I think that as long as you have the support of the community, and I can't see why you would not, I think that would be the way to go. And then of course, it would be enforced by the corporation's legal counsel. Next question here, Jerry DiDonato. Can a board deny nominations from the floor at an AGM? And if so, what legal measures are required, if any? So it's a very good question. In order to run for the board, you need to have the appropriate qualifications. And you may ask, what are those appropriate qualifications? And my answer is going to be, in many cases, not many. So you are allowed, by way of your operational bylaw, to put in place qualifications to be a board member. So you may say, well, it's not a great idea for a husband and a wife to both be board members at the same time. It may not be a great idea for people that are joint tenants that own the unit together, even though they're not husband and wife, to be on the board at the same time. Maybe we should have owners who are residents on the board, or just owners. Or maybe we should say it's not so good to have non-owners on the board. We don't want tenants on our board. So these are all things that can be put in qualifications in order to be nominated for the board. So on the basis that whoever wants to run for the board has qualifications, then the person can run from the floor. The thing about running from the floor is the chairperson of the meeting would have to ask questions of the prospective candidate regarding disclosure. So there's a disclosure statement that all potential candidates need to fill out and send in if they want to run for the board. If somebody decides to stand up at the AGM and run, those questions have to be asked to that person at the meeting. Eric Adams, we're going to get to you in just a second. What I'd like to do now, and what we do in all of our live stream sessions, is we read our fan mail. And so I'm going to read some fan mail, and then we're going to get back to some questions. So we had one here from a condo manager, and she says the following. Hi, Brian. I have been watching your videos during the pandemic. Fantastic idea. They have been very informative. I hope you are taking on new clients. Yes, well, thank you. I am, and I thank you for your kind words. Next comment. Brian, I hope you are doing well. It is so nice to see you weekly on the live stream. The information you are providing is so informative and extremely helpful, and your sense of humor adds positivity to the life we now live. I wish my board chooses you as our lawyer. Thank you. Here's another one. Board member. All our board members watched your video stream session at noon today, as we do every week. We all find the sessions very helpful in the midst of this unusual pandemic time, and your live questions and answer format is excellent. Keep it going, and how about a saxophone solo before signing off? Thank you very much. So as many of you know, the cat is out of the bag. I do play a saxophone, and I've been considering playing a tune for everybody to help out everybody's morale, because once you hear me play, you'll say, if that guy can play like that, then anybody can play, and you'll feel better about yourself. But properly speaking, I may do that one time. I'll see. All right. Last piece of fan mail here, and then we'll get back to some questions. Here is another fan mail for your ever-growing collection. I really enjoy your talented ability to take questions off the cuff and answer them very well, even in a minute or two. I guess it takes over 25 years of experience being a condo lawyer. In my case, I'm almost 17 years as a condo manager and a consultant, so I guess I have a few years to go, though a day never goes by without me learning something new. Thank you for investing your firm's time and resources on improving condo knowledge within the industry that is getting ever more complex and multi-dimensional, especially with many new managers being hired. Well, I appreciate all the fan mail, so thanks a lot. I will continue to read the good fan mail and equally the bad if we get that. So again, if there's something that you'd like us to cover, you can chat, you can put in the question on the chat. If you're shy about putting in a chat, or if you haven't figured out how to do that, it's not a problem. You can send us an email, put out your question, we'll answer you by way of an email, and we can read out your question at the next session. So let's get back to the questions here. We currently have an open position and one expiring. If the AGM is delayed, can we appoint someone to the open position and have the current incumbent stay on until the AGM is held? As long as you have a quorum of board members, so if you have, for example, a board of 5, your quorum would be 3. Your quorum is your majority. As long as you have a quorum on your board, you can appoint people for vacant positions. That appointment would last up until the next AGM, in brackets, whenever the heck that's going to be. So you can always appoint. It's not a problem. Now, if you're, by the same token, if your term is up, for example, if your term would have been up in March, and of course then, or December, and COVID came along, you haven't had your AGM, your term should have been up, but you're still on the board. So you're still a board member, and you will be on the board member, you will be on the board and the board member until such time as you do hold your AGM. So the only way out for you is to resign. But you're still, other than that, you're still a board member. Danielle Brooks, can we ask residents to move in or out after a certain time, like 8 p.m. to limit delays during peak times? Absolutely, you can do that. Many condo corporations have enshrined the move-in and move-out times and the procedure either in policies or rules. Absolutely, as part of managing your condo corporation, you can't have mayhem and chaos. So for the move-ins and the move-outs, definitely have some policies in place that all of your residents are knowledgeable about. And so they're not going to be yelling and screaming if they want to move out on a Saturday or a Sunday, and those times are either booked, limited, or unavailable. Next question. Kerry Wong. Hi, Brian. With virtual AGMs becoming more likely, what happens for owners who might be disenfranchised? Example, technology challenged. Is any exposure is covered via proxies? So this is a very good question, Kerry. We now have the ability, and we had the ability already, but we now have the ability to move forward with virtual meetings and electronic voting at meetings. And we can do this without a bylaw because of the emergency order and the amendment to the Condominium Act. So once the emergency order is rescinded, you'll still be able to have electronic voting and virtual meetings, but you'll need to pass a bylaw in order to do that. At the present time, you don't have to pass a bylaw. That was something that the emergency order suspended for now. But the question is, if you have a community that is not technologically savvy, or there are a number of people that are not technologically savvy and would not be able to participate in an electronic meeting, what can you or should you do? I think it's only appropriate as we move into the electronic era here to have the ability to vote either by proxy or electronically. I think you should always put in a paper proxy for those people that will not be able to attend the meeting electronically. I would make best efforts to try to assist people so that they could, but there are people that will not be able to do that. Again, you can't have an in-person meeting during the emergency order because you cannot have a social gathering of more than 5 people. So once you have your condo manager, your assistant condo manager, whoever you're giving your proxy to, let's say the president of the board, that's 3. Maybe your condo lawyer is 4, and maybe your auditor, I don't know, that's 5. Everybody else will not be there other than electronically or with a paper proxy. So you have the ability to go either electronic or paper or a combination, a hybrid, and I would do a hybrid because I wouldn't want to disenfranchise those people. Eric Adams, we have an open board position and one. I think that question already came up. Okay, yeah, it already came up. Jerry D. Donato, further to Eric's question, can an appointed board qualified owner to a board be acclaimed as a board director without an election process? I'm not quite sure if I understand the question, but in order to, if you have a vacancy, you can appoint. The appointment's going to last up until your next AGM. You can't have an election. You can't have a director voted on without an election. So, that's either going to be an electronic meeting or a paper meeting. I'm trying to answer the question, but it's difficult. I haven't had my drink yet. At 12:42, I'm going to have a liquid lunch to understand that question better. But if you want to rewrite it, you can. So here we are. If there's any further questions, I want to answer them as well. You have here a subscribe button, and if you want to press that, you'll be notified of all of our upcoming live streams. If you are enjoying what we're doing, you can also leave a Google review for our law firm. That will be helpful. We have here Fabio, question. In regards to the moving of residents, how can the board enforce the time of moving in or out? Well, you do that through the, 2 ways. One, if you have a concierge or security guard, the security guard is there to ensure that people are only moving in and out during the required period of time. Number 2, if you have a key for your elevator, you make sure it's not on service. This is a matter of, managing your common elements. And again, it's either concierge, security, and if you have neither of those, I would suggest you call the police. They can come and they can tell someone that what they're doing is contrary to the established rules of the corporation, and they can use moral persuasion to stop this. You just can't have people moving in and out for many reasons without notification. Donald Bala. Hi, Brian. We opened the barbecue and the tennis court at our site. Owners are not following social distancing rules. Can we legally ban them from using the above amenities for the entire session? Is that legal? So this goes back to what I said before. Somebody asked, can they want to open up the barbecue? And I said, well, and can you force people to wear masks and disinfect the barbecue, etc.? So the thing is this, as I said before, and I'll just repeat it. You can open up certain of your amenities, but you also need to use common sense. There's a difference between can I do it, am I legally entitled to do it, and should I do it? I'm of the view that it's not worth doing because we need to finish COVID-19 because it's likely wanting to finish us, and finishing us is not a good idea. Finishing it is the good idea. And we do that by sacrificing really what are small things in life. Having your barbecue is a small thing in life. So let's not make it a big thing. You can go without your barbecue. It's not going to kill you. COVID-19 will. is likely to. So myself, I would say I would follow closely the lead of the province where it makes sense. A condo corporation can be more restrictive than what the province of Ontario wants to do. The province of Ontario can say, hey, construction's open, go knock yourself out. And a condo corporation could still say, well, no, we're going to do our construction on a gradual basis, whether it's in suite or outside. So personally, tennis courts, yes, they're outside as long as social distancing is adhered to. Barbecue, to me, close people will be closely, will be in close proximity. They'll be touching the same things. It's not disinfected. I really don't like that idea. So the question is, now that Mr. Bala has generously opened up the barbecue and the tennis court, and there are people that are not following the social distancing rules. The question was, can they be legally banned? So what they're doing, if you're not following the social distance rules, you are breaching the law, because there's a law now, there's an order, and there's a law. And I would deal with this in the way that I would deal with any breach of a law or breach of a rule. I would definitely suggest management first send out a letter and outline from an educational point of view what people should be doing. If the letter is not going to be helpful, and it won't, it will just be helpful to make Mr. Bala unpopular as a condominium manager wanting to do a proper job, I would then suggest that a letter go out by the legal counsel, which oddly enough people pay more attention to than 3 letters from their manager. You'd think that getting 1 or 2 or 3 letters from your manager would do the trick, but my experience has shown that it does not. And I would therefore suggest that that letter be sent out and the matter gets escalated if this thing continues. In fact, up to the point of where we will have to consider disallowing that person or those people from using those specific common elements. So I'm in favor of that. I'm in favor of education first. If education is not going to work, then we have to move forward with a more stringent measures, which may ultimately result in a disallowance of the use of that common element. Shelley Robinson. If someone is nominated from the floor at the AGM, but is not in attendance at the meeting, and disclosure information is not available or able to be disclosed, are they still eligible as a candidate? To be part and parcel of the qualifications of a board member under the Condominium Act as amended is to fill out this disclosure statement. If you don't fill it out, and if you don't show up to the meeting, and the chairperson does not have a chance to ask you those questions, as chairperson, I would say that candidate's nomination could not be and should not be considered. Okay, there's a reason why the Ontario government put certain qualifications into the Act, and those qualifications have to be fulfilled. And one of those qualifications is for a disclosure statement to be either submitted in writing or orally. And if you can't do that, I'm going to take the position that the person is not eligible. All right. So we still have, as I said before, we still have the COVID issues as we're moving forward with phase 1 of reopening business in Ontario. There's still a number of closures, as we all know. So just to reiterate, outdoor playgrounds closed, whirlpools closed, spas closed, spray pads, wading pools, water slides closed. Outdoor playgrounds that have structures, play structures and equipment are closed. You are allowed to have tennis courts open. You're allowed to have putting greens open, but you must, again, adhere to social distancing. You're allowed to have community gardens, but again, social distancing is required as set out by the authorities. You can walk through parks, you can use parks. The only thing you can't use in the park is the recreational facilities or the outdoor fitness equipment. However, my understanding is washrooms are still available for usage, but nothing else. Now, for those of you that got the FAQ, the frequently asked questions for COVID-19, one of the footnotes leads you to a page from the Ontario government, and it sets out that how you can make your condominium common element area or your workplace safe. And I suggest that you should go to the FAQ. There's a section there on amenities. And there's a section on how to make your workplace safe. You should go there. You should click on those footnotes. You'll get the pages from the government. It will be of a great assistance to board members, to residents, and to managers that will show you exactly the steps that you need to take. A few more questions here before we wrap it up. Andrea Thompson, if a resident, God forbid, should contact the virus via a barbecue, can the board be sued? Why did I know that question was coming? Well, look, the thing is this. As a condo corporation, the condo corporation has the authority and the obligation to manage and to manage the common elements under the Occupiers Liability Act. The Occupiers Liability Act deems the condo corporation to be the occupier of the common elements, and therefore, if as an occupier, the condo corporation has a obligation and a duty to ensure that the property that's brought onto the property brought onto the condo corporation, or people that come onto the common elements, are safe and secure. And they would definitely, as far as I'm concerned, if you could prove that you caught the COVID virus from the barbecue, and that may not be provable, certainly there's going to be a lawyer who's going to take that case and is going to bring wreak headaches and havoc on the condo corporations, and it would likely, obviously, I mean, I assume it would be picked up by the condo corporation's insurance policy, but we'd have to take a look at that. But this is one of the issues there. You are in the common elements, and all of a sudden you get sick. Not only do you get sick for yourself, but now it's a whole issue in your community. And from that one person getting sick, how many other people got sick using the barbecue? I mean, this is the thing with COVID. It's a disease. It's a virus that it's very susceptible for people to catch it. So why would you want to go there? Let's all agree that we don't want to be COVID idiots, and we'll have like this big sign on our forehead that says, "I'm not a COVID idiot." And if you want to be a COVID idiot, go somewhere else for your barbecue. I know people love barbecues. I love barbecues myself, but I'm going to go without barbecues for this summer if it's going to help all the people that are taking care of people with this issue, and so that we can contain and stop the spread. Next question here. Kerry Wong, if a corporation institutes a mask rule, is it necessary for the corporation to have a supply of masks available for residents or visitors? I'm going to suggest it's not necessary, but I'm going to also say that, for the nominal cost of a mask, it certainly would make common sense to do that. So, if you put into your rules, let's say that you must wear a mask in the common elements, it would be good if you had masks available for those people that didn't have a mask. They could take one from the concierge desk. That's a nice area where the mask is kept in a clean area, secure. and they get their mask and they keep their mask and they wear the mask when they go in and out. Why would you wear your mask at Costco so that you didn't potentially infect other people or they didn't infect you, and you wouldn't do that in your own home? It doesn't make sense. So I would suggest education, encourage people to wear masks. If it's a problem in your building, I would consider putting in rules. We need to do what we need to do to move ahead and finish COVID-19. The longer we delay, the longer we procrastinate, the more we eat our steaks on our barbecue, the more we go around coughing and sneezing in our lobbies without masks, the worse it's going to be for everybody. Next question. Should the board ask the agents and potential buyers/tenants to sign a waiver in which they agree that they will not hold the corporations responsible if they contract COVID-19 on the property? Leo, I knew this was coming. So the question is, do you think that people should sign a waiver? Well, it's a nice idea. The question is, I show up at the building and I'm either a resident or a visitor, and the concierge or the security says, Brian, you have to sign this waiver. And I say, well, no, I'm not signing that waiver. What are you going to do? Are you going to not let the visitor up? Are you not going to let the resident up? It's going to be a real issue of enforcement. So I think that, you're talking about buyers/tenants. I mean, I'm thinking when you say tenants, you're thinking of prospective tenants, people who want to rent there. At the present time, the RECO, the Real Estate Council of Ontario, has put out suggestions for real estate agents. Number one, there's an order already in place that prohibits open houses. You are not allowed to do open houses, and the Real Estate Council of Ontario has suggested very strongly that the showings or viewings be limited to when absolute essential visits. So I think that the issue of masks is not really going to be a big issue, because there's going to be no open houses and the showings should be virtual, and you shouldn't be allowing a lot of showings in the corporations at this point in time. Bruna, resident is requesting girlfriend to come live with him. Sorry. Should we allow that? I don't know, Bruna. What do you think? I mean, it depends on what your attitudes are to marriage. Maybe I'm getting this question wrong. Should we allow this? Should both of them be asked to quarantine for 14 days? So this is a COVID question. So somebody wants their girlfriend to come and live with them, and should that person be going into quarantine for 14 days? Look, the quarantine really is for somebody who either has traveled, someone who's traveled who went out of Canada is now back, they've traveled. It's for somebody who has been in contact with somebody who was suspected to have COVID-19. But apart from that, I'm not suggesting that you need to insist somebody go into quarantine. There's a lot of people that are practicing social distancing, and if the two people are going to live in the same household, I don't see it as an issue, providing they shouldn't otherwise quarantine. In other words, they haven't traveled and they haven't been in contact with a known COVID-19 person, someone who's got that. Leo, thank you, Brian. Have a fantastic day. Carrie Wong, many thanks. So unless there are further questions, I think our time is basically up. I need to go to my office and handle all of the many questions that are coming in today from concerned board members and condominium managers, because in this business, there's always a crisis, as you know. Okay, here's one more crisis to handle. If a tennis player refuses to sign the waiver, can we legally stop them from playing tennis? I would take away their balls. And with that, I'm going to leave you all with that nice thought and my attempted humor. Again, hope to see everybody next week, Wednesday at 12 noon for the AMA Ask Me Anything. It's going to be hosted by Bradley Chaplik. Again, coming up Friday, instead of our condo case law corner, we're going to be having our condo spotlight, and Brad Chaplik will be interviewing John Jacobs from the Canadian Cannabis Dispute Resolution Center. So if you've got bad cannabis smells in your building and you want to know what to do, and you need to potentially mediate this situation, tune in to wait for Bradley's video, and you'll get that on Friday. Again, if you're not on our email list, you can click the FAQ and you'll be able to get there. And then last question. How can you tell if two people have COVID-19 unless they are both tested? Well, again, I'm not a doctor, but unless you if you don't have any symptoms, I'm going to say, and you haven't had any symptoms, you're likely that you don't have it. I mean, most people are not getting it, but people can always test it if they feel that they should. And that's it. Jerry Donato, you're laughing. Well, that's great. So I want to thank you all for coming. Look forward again Monday. You'll be getting your updated FAQ, and I hope the day is going to come one day that we're going to be able to say that we thank you for your patronage on our COVID-19 FAQ, and I hope the day will come to say that we now have a vaccine. It's over, and even if it's over, I'd like to continue doing our AMA live streams on Wednesdays and continue sending out our case laws. For all of you that are watching, if you're enjoying it, let us know, or let your fellow board members or fellow condominium managers know, because there's a lot of great information. I can tell you this, you don't have to get off your chair to get great condo information and to learn a lot of stuff. Just hang on to our YouTube network and we'll take care of you. Have a great day, everybody. And from Horlick, Levitt, Lella, this is Brian Horlick taking care of your condo business. Have a great day.